Hi everyone, my name is Kuldeep Jauhari. I am a lawyer practicing law in the Delhi NCR region, and I started this thing a while back. I started making videos, but it's been a while since I put something out, and I was just recently working on something when this struck me that I can probably share this with everyone since I thought it's really important and it is something that can save you a lot of time, effort, money, all of that if you take it up proactively and if you give it that heat that it needs. So, what I'm going to discuss today in this video is legal notices and their importance. Now, as all of us know, a legal notice, it's a very basic thing, it's a very simple thing. It's something that you send to a person when you have any grievance against them, and it is something you do before you go to the court. So it is sort of an intimation and a sort of a warning to a person that in case they do not correct this thing, you will be forced and you will be constrained to initiate legal action against them. Now, what a lot of people don't know is that there are certain statutes in India which mandate the sending of legal notice before you go to the court. So, for instance, the NI Act, the Negotiable Instruments Act, there is a condition, there is a prerequisite for filing a complaint under the NI Act that there should be a legal notice served upon the defaulting party and they should have failed to respond to it is only when you can file a complaint there. Now, that is a law which requires you to do it, so that kept aside, that there is no other law as such which requires you to send a legal notice to a party and only then can you pursue your right to sue them or to file a case against them in the court. But what most people don't know is that though it is not mandated under the law, but no court will ever take an adverse action or take an adverse view against the fact that you first sent a legal notice to a party and then you came to the court. So what I'm trying to differentiate here is that there are laws that specifically lay down that you have to send a legal notice and only then can you file it before the court, but there is no law which bars it specifically or which says that no, you cannot send a legal notice and you will directly have to come to the court and file your case without sending a legal notice, which keeps that space open that for any and every grievance or for any or every dispute that you have with a person, you always have this right to send them a legal notice first, and then probably if you don't get a response or if the response is not satisfactory or if there is no scope of settlement, then probably you can go to the court and that right is always there. I mean, of course, you have to be within the limitation period. It's not like you file it 10 years later, but it's always there. So now we will come to the advantages of legal notice. What are the advantages and how can it save that time for you? So first and foremost, if you don't go to the court directly and if you send a legal notice to a party, the first advantage is that slight scope of an amicable settlement or something more on a casual note, or how do I put it, like on or something which is less serious and less grave in nature and not a judicial process. So when you send a legal notice to a party, it is just one step before the court proceedings, but in a way it is very different and very relaxed from it because you have not attacked the other party to whom you send the legal notice understands that you've given them a chance. You had this right with you to go to the court directly and file a case and get your thing done, but you've sort of given them a chance before doing that, and you have warned them that in case you don't honor this legal notice or in case you do not honor the terms of the settlement or the breach that whatever you've done, in case you don't do that, then since we've already sent this legal notice, it will not take us much time to go to the court also. So when the other party understands that you sort of left that room for discussion, it is very, very likely, from personal experience and from whatever cases I've done, 8 out of 10 times I would say that in case you send a legal notice, a strong worded and a good drafted legal notice, in case you send it across, 8 out of 10 times the other party is going to respond to it and your thing is most probably going to get sorted out amicably and there's going to be a settlement. First thing is this, that in case you send a legal notice, the other party always, like most of the times, will understand and will want to honor that and will want to settle it out of the court. Because the problem is that in case you file a civil suit, or in case you file any sort of criminal complaint or any case against a person without sending a legal notice, then even if they want to settle it with you, they don't have a chance, they don't have a choice to do it, because since the thing is in court and the entire judicial process has been invoked, and every like the judges and the court is involved, they don't have a choice to settle it with you verbally. It is their duty, they are duty bound to file their reply, to file their version of the story, and to rebut your complaint, whatever it is. So once all of that starts, then this amicable discussion and this scope of settling the matter goes out of the room. First thing is this. The second thing is, which I have seen happen in a lot of cases, and which is very funny in fact, is that you don't send a legal notice, you file your criminal complaint, you file your civil suit, you file this, that, whatever it is. Then the thing sets into motion. It goes on for maybe say 6 years, 6 months, 10 months, a year, 2 years, something like that. And then again you come back to this same situation that we were talking of, that is settling the issue. Now now the only difference in the situation is that the court is going to ask you to do it. The court will tell you, see, they say something, you say something, theirs is also grey, yours is also grey, we don't know, there's no clarity on who's right, who's wrong. So we would suggest that since this is something that can be settled, so we will direct you to mediation. So they will refer your matter to the mediation center, where there will be another person who's the mediator, who's not a judicial authority and doesn't have any power to decide the case, but he will try his best to settle the matter between the parties. So either your matter will be referred to mediation. If you don't do that, the judge will say, okay, you don't go to the mediation center, but you sit outside somewhere, you have a meeting with the other party and you settle it. Now, the thing will be the same. What you could have done before filing this case and before starting the entire process, you again do that same thing. But the only difference is that now you will maybe have to, spend 10 times the money that you would have done when you would have done it before filing the case. Because there is now a team of lawyers involved, there is lawyers from both sides, there is the court involved, so the settlement agreement that you arrive at will have to be much more formal than it would have been before at the time of the legal notice stage. If you've done a settlement, it's not it's not very important to have it worded or have it documented. But once you do a settlement agreement after the order of the court, it is necessary to have it documented. There will be a complete settlement agreement which will be attested, notarized. There will be witnesses who will witness it, who will give their witness to the settlement agreement. So it becomes much more complex. It will have to be very strongly worded. The rights of the parties will have to be laid down. So all in all, it will become much more cumbersome than it would have been if you would have settled it at an earlier stage. Another very probable chance is that if you settle it after the order of the court, there is a very strong chance that the court will impose cost on either of the parties. So the reasoning behind that is that the court is of the opinion in either criminal matters or in civil matters that since you've taken up judicial time and you have wasted the time of the court, there is so much that you could have done, but you haven't done that, and since all of that has been done, so there is a certain cost that you will have to pay for it, and that could be either that the court will order it to be shared by both the parties, or the court could burden either of the parties with the entire cost. So the long and short of it is that if it is a dispute which is related to money, which is related to fraud, to cheating, to misappropriation, to maybe conspiracy, all of these things, if it is a financial fraud, a financial dispute, or a breach of an agreement or something of that sort, which is not very grave and which is not very heinous in nature, or a very, very severe or serious criminal offense in which there is no scope of having this liberty or this timeline to exchange legal notices and send across things. If it is something which is of not that sort, and something in which you have that time to deliberate upon the matter and maybe discuss it with the party, then it is always advisable and very prudent to first send legal notices, the time and the money and the effort that you would put in that, in preparing that entire case, in putting in all your time and all your brains and collecting everything, rather like just spend one fifth of that time on getting a legal notice drafted, a very like a very crisp and a very strong worded legal notice which lays down your entire case, and just send it across to a party. If you can do it yourself, very well. If you cannot, then take legal help, but go for a legal notice first before you file a case in a court. That will save everybody, including yourself, a lot of time and your effort and your money. I hope this video was informative, and I will now be more active on the channel and I will put more videos. Thank you so much.